Ladies and gentlemen. Hopefully you can hear me. I don't know the microphone whether it's working or not. So normally I walk on the stage, but okay, after 4 editions, I'm tired, and today I will stay here. Also, I think the microphone goes better if I stay sit here and I don't move. Okay, well, first, why you don't see the slide? Ah, okay. Well, waiting for because we tried the beginning. Okay, as usual. Well, seems not perché l'ho provato all'inizio, cioè quando sono venuto l'abbiamo provato con il collega e funzionava, e adesso perché non mi fa la provato questo, prendiamo il duplicate, se no lo rimettiamo di sopra, però ho bisogno della chiavetta. No. Perché infatti sono venuto prima, abbiamo provato, funzionava. Ok. Però adesso il problema è che non vedo. Ok, lo faccio un po'. Ok. Well, okay. Try to. So I will get the stiff neck after this presentation because I have to watch there and to you. Well, okay, we'll see. Anyway, so my name is Domenico Golzio, so I'm Italian. I have a degree in physics. I've been working in industry for several years. I got some I wrote some technical papers. I got also some patents. And in 1990, I decided to go to the European Patent Office in Munich. And well, 1997, I moved to The Hague. And here you see more or less my sequence of job I did at the European Patent Office. So I started as an examiner in telecom, in electronic circuits first, then telecom. Then I moved in 2011 in the IT department, where I'm now responsible for developing search tools. And for instance, if you know the ESPASnet, so the public patent search tool in internet used provided by European Patent Office, well, I'm the guy behind that. So when it doesn't work, is me doing something wrong. Okay, so this is a little bit about myself. So now I go to the actual presentation. And well, it's a very long presentation. So you see 120 slides. Of course, we will not present 120 slides. You will get anyway the the presentation will be posted in the site of the PhD Plus. So then you have time to read more details, because we are going to skip some slides. Well, first of all, it's a pleasure to be here, and is the fourth edition, fourth time here in Pisa. Unfortunately, I arrive always late, and I have the flight at 7 o'clock, so I cannot enjoy Pisa and Italy. But anyway, so is what is true is I'm enjoying staying with you and getting your question. Very often are very difficult questions and not able to answer. But as Dottoressa Magliocchi knows, I leave you at the end my email, and the students normally they write to me, and then I reply by email. But also what is important is every time I add and change the presentation, because I try to include questions or to change a little bit the presentation, as I did again this time. So what we experienced last time, we were spending a lot of time about the intellectual property right in general, so trademark, copyright, industrial design, because in fact this is interesting. There are a lot of curiosity around these subjects, and we were not covering too much the presentation about patent. So this time I will skip a little bit, or we go quickly through the general part of intellectual property right. I stay more on the patent part, especially because I added something about the computer implemented invention, business methods. So is the area normally this faculty works, Professor Ferragina works. So, and the question were coming more in that area. I also know you have already a certain background, even though this is the first lecture on intellectual property. You will have next week a patent attorney here. He will go much more in depth on certain details. But anyway, we try to do our best and finishing in time. I don't think we have a break, so we go straight to 5 o'clock, because otherwise I miss the plane and I cannot go back home. So quickly, so this is the way you have new ideas, and very simple. Yeah, everybody says as a first things, I have an idea, but in reality, what people really say, at least as a second step, is this is my idea. And in fact, this is very important, because we are introducing here the concept of property of ideas. The concept of property is easy, is something very easy for a computer. You own a computer, you own a car, a bicycle, a house, etc. With the idea is a little bit difficult. And then, as you can see from this picture, so what happens is somebody, if your idea is a good one, somebody wants to steal it. And then the question is, how can I protect this idea and to avoid that? So one way to protect the idea is don't share your idea. So keep the idea secret, keep it for yourself. But the problem is you want, okay, so as the heading of the PhD Plus 2015, so creativity, innovation, fine, but then also you are talking about entrepreneurial spirit. So you want to make money, you want to make business. So and then if you want to make money, make business, then you have to show your invention, to commercialize. And of course, when you commercialize your invention, people can see it, copy it. You know, there is this reverse engineering situation. So technology, technique. So basically, you can somebody can easily copy your invention. Or if somebody copies your invention, it's difficult to prove this person has copied your invention. So this is why, okay, I put there, it's difficult to enforce. So, yeah. So then, as is in the slide, so the intellectual property rights are coming to help us. And basically, we identify a palette, a portfolio of intellectual property rights. So if your idea is of technical nature, so normally you will use a patent to protect. If your idea is about the appearance of a product, you will use industrial design. Okay, as you recognize, Vespa has been designed around the Pisa in the 50s. You have a trademark, whether if you want to protect a distinctive sign, and you have a copyright if you want to protect literacy creation. So here basically some more definition. What is very important, even though I understand most of you are engineers, what is very important here is all these tools are, even though you are going to do more technical invention, let's say, so you will use more patents or utility model or petty patent, still industrial design, registered design, trademark, trade names, copyright are very important also for you. And in fact, you should use this in combination, and you will see in practice, in the news also, the fight between big companies very often is about industrial design, trademark, and copyright, and not only patents, even though the invention is about technology. The product is a technological product. So quickly to industrial design. Industrial design, as I said, is to make some goods, some product more appealing to the public in order to increase your sales. Industrial design is a right granted following a registration, and is normally intended for a non-functional aspect of your invention. So, for instance, you have seen the Vespa before. The industrial design is about the shape, the appearance of the Vespa, but doesn't cover any aerodynamic aspect or the fact that the Vespa protects you when it's raining or the mud, or okay. So is only about the appearance. You get you protect in that way the aesthetic value or the product of your goods. Can be a complete object, can be part of the object, can be bidimensional, three-dimensional, and as I said, has nothing to do with the technical function, but still there are some exceptions. Some examples here. The fact you have and here you can find it also the equivalent physical document protecting this invention. By the way, are all Italian. But the fact that you have industrial design for a Ferrari. You prevent people copying the shape of this Ferrari. Interesting, if you read this design patent, also protect not the copying the car in one-to-one scale, but also toys and models. The fact there is a coffee machine Lavazza doesn't prevent others to make new coffee machines. So in fact, there is Nespresso, etc. But they cannot copy that shapes. There is a registration process, must be new, and so you cannot just copy something already existing, and also must have some individual features. There are plenty of cases of infringement. As you know, Vespa is being copied by other companies, Smart and other objects. If you own prevent others copying your invention. In terms of industrial design. Questions? Okay, there will be an examiner of checking in database other design and well, seeing similarity and deciding whether they are similar or not. So, and then yes, I mean, and then you will see in patents, all this is not exact science, precise science. There are a lot of gray zone, and okay, definitely is the difficulties in enforcing in. This is why also we will see later you need to have expert advice before filing or not filing, or thinking you are putting something in the on the market which maybe is similar, but then you say, well, okay, it's not really similar. Okay, I can make this design and not infringing an industrial design, but in fact you do. And so you must be very, very careful when you do that. So yes, cannot help. There is there are definitely blurred lines in this. Trademark. Also here we I can well, okay. Trademark is about branding, is about create individuality for a company, for a product, and the idea is to manage to distinguish your product or your company from another. The idea is to create fidelization with consumers. So if I'm a producer of a fashion, car, or telephones, whatever, so I have my brand, I have my and when I use this brand, it means you get a certain quality, and your brand brings a certain level of reputation. So again, this is something you do because you want to protect the business, your business, protect your tradition, protect the work basically you have done. So there are several type of marks, trademarks. So concerning the origin, so the company, as you can imagine, trademark specific for the product. So I now, because here I see Apple, so Apple is the origin, the company. Then you have a trademark like iPhone. But also you have services like insurance services, they have trademark. We have also certification trademark. For instance, company you certify, quality certified, they can use certification trademark. Collective trademarks association of producer of Parmesan, I think, or Grana Padano, something like that. So all this helps to create a reputation and protect your products. So you know what happened to iWatch? What is iWatch? Oh no, it's Apple Watch. Somebody else, by the way, an Italian, registered in Ireland 4 or 5 years ago, iWatch. So now Apple couldn't use iWatch because, and the guy decided not to sell, to transfer the rights to, was not to sell it because he said, okay, I can defend, I can survive, and I can put on the market my own iWatch. So you will read the story because all this is very easy to find, as I said in the news. So okay, you don't even have to listen me, but just Google a little bit, you will find all this. But okay, this is interesting. And now I just read this week, Apple Watch, smartwatch, is suing Apple because is close. And then we go back to your question. So how much close Apple and Swatch are close? I don't know. The name, the trademark. We were talking about the trademark. We are not talking about the invention. So you see the product. So you see the blurred lines is one of the issue we have here. There are trademark can have plenty of different form, can be words, names, surnames, Apple, Fiat, Ferrari, can be geographical names. But okay, so you got the feeling. Can be also smell, perfumes, tennis ball smelling grass, or and there can be also tactile trademarks. Okay, so I'm not going. As I said, there are plenty of things you can just Google this. So you can have these kind of things you can play yourself, and then you can imagine all these trademark. They bring messages. For instance, Toyota somewhere here. Toyota. These three ellipse. So they imply in Japanese quality, the quality, passion, and other things you will discover yourself. So Adidas also is there, yeah, means climbing. So they bring messages, all this Amazon, there is a little arrow, I don't know, I cannot find Amazon anymore, so it's somewhere else, somewhere there. There is an arrow between A and Z, meaning Amazon can sell everything, even the Italian pasta. So I'm sorry to mention all the Italian stuff, but also important trademark are also the slogan. Interesting also reading about the slogans, because some cases can be also counterproductive. Let's make things better, Philips. What does it mean? What they are doing now is not okay? Okay, anyway, so there are a lot of things to LNG is nice because life is good, okay? Be optimistic. Trademark can be registered and not registered again, so there is a procedure of registration, and something is very important to, again, there is a examination procedure. So there is somebody checking whether the trademark exists already or not, whether it's similar, deceiving, and allowing, granting this trademark or not. I forgot to say this registration, like also for the industrial design, have a limited lifetime. So the industrial design you can register only up to 25 years, but then you don't have the possibility to renew. While the trademark you can register, you renew your trademark. So this is why Coca-Cola went from the industrial design, the bottle, to the trademark in 1915, so 100 years ago. So to the trademark, and then they are renewing and changing a little bit. So because they can do this forever. Also important is a territorial right. So you have to have a trademark registered in all countries you want to protect. So people can copy, can use your trademark in a different country, if in a country where you have not registered your trademark. For instance, now we are trying to register trademark in different countries where people are using the search engine for examiner, which is called the EPOC. EPOC is EPO query, European Patent Office query. And fun enough, we are doing this in China because the Chinese Patent Office is using our tool. And okay, maybe it's secret, I don't know. But anyway, in the procedure now, the rover challenge our EPOC trademark or request registration because sounds like Evoque, which is the car of the car, you know, the SUV produced by Range Rover. Of course, the Rover, of course, are completely different things. Still, they are doing that. One problem, if you have in mind to do a trademark, be careful on the having your trademark used as a generic term for a product. I put there some example like aspirin, Kleenex, Pampers, Google, etc. So all those terms, signs, started as a trademark, but then suddenly, but then they enter in the common language, and basically you have this effect of losing the brand. The trademark becomes a common term, and you lose the ability to continue to register, to have your term registered as a trademark. It's still a trademark, I guess. I don't know, we have to check whether it's registered or not, but the fact that everybody is using Google as a search tool, and there was a discussion here 2 years ago, I think, about iPhone. iPhone now is used as a replacement of a smartphone, I think, at least in my generation. I understand your generation, you are younger, you still made the difference between smartphone and iPhone, but I think people more and more are using the word iPhone just to define a telephone with a lot of functionalities and high-tech capabilities, etc. So this is dangerous because iPhone can fall quickly in this category, and certain countries can decide not to grant them, Apple, the trademark to iPhone. Of course, there were colleagues here say, well, no, okay, you are old guys, you don't understand that iPhone is something different. Well, okay, but I check, and for instance, the Swiss Patent Office decided not to grant the iPhone as a trademark for different reasons, because they found this as falling basically in this you cannot use Apple for Apple, furniture for furniture, and iPhone for phone. So this was the main reason. But anyway, be careful again. So blurred lines. So, and when you use iPhone, you should use always the telephone iPhone. You should always use iPhone, the mark, as an adjective, never as a substantive, because the moment you use it as a substantive, you risk to fall in this category. Okay, well, I'm saying this, okay, is a theoretical or practical. I hope when you have a startup, you are so successful to have a product sold so much, you fall in this category. Okay, you can infringe a trademark because, like Evoque, you use something similar. So, and Range Rover can start a procedure against the European Patent Office because we use similar things. But then here there is also another aspect, is the counterfeiting, when you really copy intentionally the trademark, the object, like copying completely Louis Vuitton bags and so on and so forth. I move to the copyright quickly. Well, copyright is intellectual property is a right, a tool used to protect the creation of your expression. Normally this happens when you put your idea in writing books or you put in recording. I don't have a copyright on what I'm saying and what will be in this video. I just signed the paper. I gave the right, but still I have the author rights. So because I could claim, but this will be automatically done, I guess, especially if it is no good what I'm saying and the lecture is bad, they will say, okay, all this has been done by Domenico Golzio. So he's the author of this presentation. So meaning I am the moral or immoral right, or I have the moral rights of this presentation. But so this is the way these rights work. And the idea is nobody else can copy the this video or the PowerPoint I'm distributing, even though, as I said, okay, well, now it's property of University of Pisa with the PhD plus 2015. And what is important to mention here, especially for the people working the software area, is the copyright has a big implication, the sentence I put there. The copyright protects the form of expression of ideas, doesn't protect the ideas itself. So if you have a copyright on the software, so people cannot copy the text, the lines of your software. They cannot copy the text of your poem, the idea of making a lecture on patents, but they can copy the content of this lecture, but they can copy the idea of making a lecture, or they copy the idea of making a software having the same functionality protected by your text. Or okay. Well, okay. Fine. The question is how much I had to modify the code, how much I had to modify a music to decide whether I'm copying or not. I try to do something here a little bit complicated. Let me see if it works, because I just read this week. Now it's difficult here, so hopefully I don't. Okay, is here. Is here. Wow. Okay, you will see a video is the censor version, because there are two videos like this. So, okay. So probably you know this. You know this song. Come on. Okay, so this is the censor video. There is another one I cannot show here, obviously. Okay, so you know that. Okay. So the daughter of Marvin Gaye was a jazz composer, whatever, in my age, basically is died already. He, in 1977, composed Got to Give It Up. I think I have here also the music. And okay. Okay, this costed 7.4 million euros to TK, because of the court, wherever it was in Los Angeles, etc., decided this song, or this song, Blurred Lines, interesting title, is a copy of this. You're seeing is the same. I don't know. And the software, okay, will be the court deciding, and the lawyer defending you, whether you are the owner or the guy copying, whether just changing the name is the same or not. So how much you can really change in a text in Harry Potter to say is a completely different thing. So
and you can analyze in a mathematical way the correspondence between one and another. With a software, not a complete alphabet. I changed all the names of variables, classes, function, methods.
I'm listening to you and just try to find back my PowerPoint. Yeah, okay, is here. Yeah, well, yeah, I don't have the answer. Is definitely in the technical area is more difficult, but I can tell you in the music is also extremely difficult. And then again, you can Google, and then you can find. I just made this example because this just came last week. So, and I was impressed not by the video, but by the title of the song, because this is in a way auto-referential. So this example tells you how much is difficult to understand and define and see. Okay, there are more details on the copyright, etc. So there are exceptions. The fact I can use here information to make a presentation, I can extract. I can show you a video for a part. Again, is a territorial right. Sometimes you go to YouTube, you cannot see the song. I know there are other systems, but I'm an old-fashioned guy. I'm only using YouTube. But then you get the message in YouTube, okay, this is not valid in your country. As you know, movies, when in TV, if you go watch via satellite TV, sometimes you don't see a movie because when I watch Rai in the Netherlands, I don't see all movies because they are maybe Rai didn't buy the right to broadcast that movie in that country. So there are a lot of facets in the copyright. Is really complicated. We can, as I said, go on a lot, but already I think we spent I think enough time on that. The only things I would like to mention here before we move to patents is again, these slides shows these rights are used in combination in all tools, basically on the products you have on the market. So really, you have to do this in combination. For the people working here at the University in Pisa, I suggest also to contact the Chamber of Commerce, Roberta Tigli, yes, thank you. Because I think there is a service helping you to understand and to follow in more detail this, especially, and there was a colleague here, I don't know whether he's still here, before the lecture we discussed about trademark, because trademark is very easy to, maybe composing a music and writing a software takes time, filing a patent even more, but inventing a new word, a new slogan, sometimes very simple. Putting this on your commercial product is something you can do easily, even without registration. But then suddenly you discover later this has been used and registered by somebody, and then this company can sue you, and then you have to pay a lot of money. So there are rights easily, you can get easily, but those are the most dangerous, because the process to get this right is very simple. And you think, just like copyright effect, you just write something, put on paper, automatically you have the right, you have the copyright. You don't really need to register, even though registration is always better. So be careful, and before you start a project and going on the market, pay attention to, or inform yourself, because it can be really dangerous. And as I said, you have a very useful and well done service here at in Pisa. What is a patent? Well, okay, I think you have your own definition. Okay, I like to have this idea of contract between the inventor and the society. So the inventor gets some form of protection. We'll see a little bit more in detail now. And the idea is, of course, because you invest money, you add a lot of shower and shampoo, etc. So you want to recover what you spent, or you want to find your place in the market. What gets the state, the nation in country, in the country in exchange, is the fact you publish your invention. So can you imagine if Thomas Edison decided to invent the lamp and then keep it for himself? So probably we'll be still here with the candle lights or so. So the society needs to progress. So then the patent is the one way to disclose